Welcome, everybody. My name is Marty Mascari. I am a contractor under the North Central Texas Area Agency on Aging and the North Central Texas Aging and Disability Resource Center, or ADRC, both of which are under the umbrella of the North Central Texas Council of Governments, and we are in the greater Dallas-Fort Worth, Texas area. We are blessed to have our partners at Heyman Hogue, as well as some guest speakers today. But before we get started, we're going to talk about special needs planning, important information for families of persons with disabilities. But I want to talk about the CEU process and that before we get started. If we could advance to slide one, Rex, that would be great. For those of you that are joining us to get CEUs today, we're providing complimentary CEUs for licensed social workers and licensed professional counselors that are licensed in the state of Texas. If you have a different license in Texas, or you have a license outside of Texas, you're more than welcome to go through the process and get a certificate and submit it to your jurisdiction if you'd like. There's just no guarantee that they will take that, although I've had people tell me they've been able to use them. So it just depends on your jurisdiction and whether they will accept that. We're also offering certificates of attendance for anybody who would like to have one of those. The guidelines are the same for both. Today's presentation is worth 1.5 hours of CEU credits. You must complete the entire live webinar and the Q&A up to the end of the scheduled time. If we go beyond the scheduled time, you're not obligated to stay with us if you have other commitments, but you need to stay with us until the scheduled end time, or if we happen to end early. You must also complete the Google evaluation survey. Zoom should give you an opportunity to click here to continue to take a short survey. It should give you that option as you close out of Zoom today, but if not, you will receive that link in a follow-up email from me that will go out tomorrow, actually. So have no fear if somehow you have a pop-up blocker that prevents that from happening as you close out, you'll get that link from me in the follow-up email. The evaluation must be completed by 5 p.m. on the 7th of June, and then give me to the 7th of July to get those certificates out. And for those people that were with us for last month for the ethics, I have not got those out. I am sorry. I had to leave town for a week for a funeral, and I'm fighting to catch up. So bear with me, and I'll get those out. They should be out by the end of this week. So I'm going to turn it over to Sheila. Sheila, are you there?
Yes.
I'm going to turn it over to you. And I first want to ask you, CLEs.
Yes. We are offering CLE credit for this. And so if you are an attorney, and if this is something that you would like CLE credit for, all you need to do is email me, and then I will email you the course number and all of this stuff, the certificate thing that you need.
And I will have Sheila's email address in the follow-up email, directing you to email her if you're looking for CLEs. Very good. If you will introduce Rex, that would be great.
I will be happy to. I'm so thankful to be here today. We've had, those of you that are in the Metroplex, we've had horrible weather. And I know surrounding states have as well. Oklahoma, Arkansas, I know so many states have had terrible weather as well. So we're very thankful to be here, and we're thankful to present this to you, because I know that any family with special needs, a special needs individual, can use this information. And I felt like it was so important that we needed to do it again. So today we have 2 partners that are joining us as well, and they will, they have some extra resources that you are going to need. And a lot of times people don't know about them. So I wanted you to know that there are other resources out there. But first off, we're going to hear about the planning piece, which is absolutely incredibly important, and can be confusing if you don't have the right person handling it. This is and especially if you don't know what you need to do. Rex Hogue is a founding member of Heyman Hogue, the law firm that I work for, and he has been in this practice for 30 years. So he in this line of estate planning. So he is very well versed on any question that you might have. So he has put this together to be the most helpful that he could be to families of special needs individuals. And so please, without any further ado, we welcome Rex Hogue.
Thank you, Sheila. I am going to move very quickly today. I have a lot of material to get through in the time. I'm going to start by talking about planning dragons. We're in the dragon slaying business, actually. Administrative dragons include powers of attorney failures, guardianship, probate, medical documents, tax issues. I'm not going to take time to detail those. We won't spend a lot of time on taxes today. And then predator and creditor claims, protecting yourself and what you leave others. And I'm going to show you how all of these dragons come into play when it comes to special needs planning. We're going to do an overview of all three of those dragons and how they apply. And then we're going to cover special needs planning itself, for special needs trusts more specifically. We're not going to cover the various types and levels of special needs, agencies that might help, and government programs, but we will discuss how to keep from being disqualified from those programs. There's a wide spectrum of people with special needs. They can range from incapable of taking care of themselves at all to very high functioning. I'm going to use the term special needs planning. Sometimes it's called supplemental needs, but I'll use special needs. All three planning dragons affect special needs. And the objective here is to not disqualify a special needs person for any benefits for which he or she might qualify. That requires careful planning, starting in the right place, careful drafting. And if you have special needs family, your good planning options are more limited. Now, when you are on an airplane, one of the things the flight attendant will tell you is that when the oxygen masks come down, put your own mask on first before you try to help someone else. That is very true in the special needs area because it's hard for people to plan for a special needs family member when their own planning isn't in place. And if they try and something happens to them, some of that effort will be wasted. Literally, special needs issues are like a lit stick of dynamite. It isn't a question of whether it's going to go boom. It's a question of when does it go boom. It will eventually happen. Now, administrative dragons, briefly, medical incapacity, 6 key medical documents. These are things that if you have a special needs family, you need to have these in place. DocuBank is a medical service forms that can get your medical documents to any hospital in the world, 24/7, 365. We highly recommend them. I've been with them for a great many years. Now, there's the other side of incapacity is the financial and legal side of incapacity. And there's 3 ways to deal with it. The first is through powers of attorney. That's where a principal gives an agent a power of attorney, which is an invitation to let third parties allow the agent to act. You're going to be limited by the authority that third party gives, not really the authority in the power of attorney. If powers of attorney fail, another way to deal with it is through guardianship. I call that the court-supervised management of assets for somebody who is legally incompetent. Some people call it living probate. We'll go through enough of that to hopefully show you that that's not the option you want. And the third is to use a living trust. It can replace powers of attorney. It can provide the necessary substitute signature, which I'll explain later. It can avoid guardianship and probate, and it can even provide instructions for an incapacitated trustmaker's care. That's especially important in the special needs context. Bare bones trusts with no instructions don't work well. For a guardianship, here's kind of what happens. If a person owns assets in their own name, or two or more people own assets together, and one becomes incapacitated, we end up going to probate court for a guardianship of the estate, which can be very difficult, or of the person, which is easier, but still not a lot of fun to go through. The other option is a trust. Now, even with a trust, people still become incapacitated, but the rules are different. The assets are managed by the trustee. The trustee holds legal title to assets. An institution cannot refuse to deal with a trustee, but they can refuse to deal with an agent. Incapacity instructions are important. Successor trustees manage. They're easy to manage, change, and update, and they work best when assets are fully aligned with the trust. I'm going to go back to easy to manage, change, and update. If the law changes, especially in the special needs context, a trust set up properly can be changed after death. Guardianship is not the problem. The problem is a person is unable to sign necessary documents to manage or transfer assets. Guardianship solves that problem by allowing a judge to authorize a substitute signature. That is why we have guardianship. Frequently, it's the only solution to the problem. Courts will almost always look for a less restrictive alternative. But is it the best solution to the problem? Well, guardianship of the caretaker is a complete disaster for the special needs person, because now you have the court involved in yet another way, and they might not be the same court. They might not, there's just all kinds of things that get complicated if the caretaker is under a guardianship. Guardianship is one of those 12-step programs. I'm not going to detail those today. I'm just going to tell you that the minimum cost that I've ever seen for a guardianship is $9,500. They're normally $30,000 or more initially. The annual cost is $2,500 minimum in my observation, but it's usually more than that. And it seems like there's a constant stream of surprises that go on for as long as the ward is alive, or until they prove to the court they're no longer incapacitated. Guardianship itself is disastrous for otherwise good estate, business, and asset protection planning, and it's especially bad for special needs planning. Guardianship leads to a lot of time, typically takes months to get one in place, a lot of money. You're going to be out the money for at least 2 lawyers, a doctor, and a social study that come out of the estate. And the professionals alone ought to tell you that this is not a cheap, easy process. Usually involves a lot of going to court with at least 2 lawyers. And just, you should know this, when you're having to pay for both of the lawyers, it gets expensive. You lose control when you're under guardianship, and you lose dignity. Nobody wants to have their family come in and testify that they're incapacitated, and no one really wants to do that to other family members. Major guardianship problems: that opens the door for creditors and predators that is otherwise shut. A lot of people don't realize that, and it complicates special needs planning. So I'm going to give you an example of a guardianship case. Carl and Myra have 3 children, Peter, Paul, and Mary. Their assets have a $500,000 home. Carl has a $500,000 IRA. They've got $1.8 million in investment accounts managed in Carl's name, and they've got a $200,000 joint bank accounts. Myra is terminally ill. She can't manage assets or herself, and Carl has Alzheimer's. Powers of attorney have failed. They do have a trust, but only the home is in it. And their trust is bare bones. It lacks instructions to help take care of them. Paul has special needs. So let's see how this works out. Carl and Myra have a guardianship of the person and estate over Paul. And now what they need is to get assets to provide for Carl and Myra. They've got to sell the house. It's no longer feasible for them to live there. And they need funds for Myra to be in a facility. Carl's better off in a facility and he's not resisting, but his concern is for Paul. Neither of them are any longer able to take care of Paul. He can't live on his own and he can't hold a job. So what's going to happen? His home is about to be sold to take care of Carl and Myra, and in a guardianship, that's who the judge has to worry about taking care of first, is the wards under the guardianship. We've got to get doctor's reports for Carl, hire attorneys to file a guardianship application, notice the interested parties, in this case, Peter, Paul, and Mary. The judge appoints an attorney ad litem. The court investigator does a background check on Peter. He's going to be the suggested guardian. Peter has to undergo approved training as the guardian. Courts may be backlogged on background checks. We found that especially in the pandemic, and it was very frustrating for people waiting on background checks. Meanwhile, Peter, Paul, and Mary may have no access to financial information except what they can find on statements, assuming that Carl and Myra have them in a place where it's easy for them to find. Mary has to undergo the same thing to get help for her. So they get to go through this twice. All the while, Paul is kind of waiting in the background. Until Carl's accounts are accessed, the kids are going to have to pay to maintain the house, pay bills, including medical bills, and they're going to have to provide care for their parents. Peter has to have a bond up to 3% of the assets. That is $90,000 a year just to have a bond. Peter has to pay this until he can be reimbursed. So one of the challenges can be, what if Peter couldn't afford it? That's a problem. The judge appoints a social work for social study, then comes a hearing. And again, I already mentioned the background checks could be backlogged. But the court in this case handled Carl and Myra's guardianships together. It didn't have to be done that way, but if you have a cooperative judge, that can help a lot. Conceivably, they could even be in different courtrooms. Poor planning for themselves makes this worse for everyone, especially Paul. Peter and Mary have to step up. Fortunately, they both live close. They're in a position to help, and they're willing. Folks, I'm giving you the best case scenario here. Peter and Mary love their brother, but they lack the legal authority to do what is needed. Now, sometimes one sibling will they don't want to deal with the incapacitated sibling anymore. So you have to ask the question, why? That's not the case here. Then, when a person dies, everything goes through what I call the estate settlement cost funnel. First thing we deal with is those administrative dragons. And I look at this funnel and I ask 3 questions. Which administrative rules apply? How many different rules apply? And where do you put your family in this process? Next comes probate expenses, and then creditors, and then tax issues. Now, again, we're not going to spend a lot of time on tax issues today, but be aware if the estate is large enough to file a 706, administrative costs are going to increase considerably, and it's going to take a lot more time. Then whatever's left over after you turn those spigots off can go down to take care of the family. Now, there are only 5 ways to pass assets. We'll read these left to right because they're the order that they're looked at. the first thing we look at is an asset owned jointly with right of survivorship? If so, it passes to one or more individual survivors. That looks very simple, but I'm going to show you on the next slide, it is not. Then we ask, okay, if it didn't pass by right of survivorship, does it have a beneficiary designation or a TOD, which means transfer on death? I call that planning by the box. I call it that because there's a box on the form where it says, where do you want the money to go if something happens to you? Whatever you put in the box, that will dictate the rules. If you put an individual in the box, it goes directly to that individual. Now, those first two, once you get it down to the beneficiaries, you're now playing by the same set of rules. It's not the same going from top to bottom, but they're the same once you get there. I'll show you that on the next slide. If it doesn't pass by beneficiary designation or TOD, we ask, is it owned by a trust? But I forgot to mention that right of survivorship, beneficiary designations, and TODs, you can lose control and they will blow any tax planning that you have done. If the assets are owned by the trust, the assets pass according to the terms of that trust. If the assets aren't owned by the trust, there's only one thing left. It's owned by individuals. It's going to go through probate, where it will be controlled by the will or intestate succession. Intestate succession, for those of you who don't know, is the will our state legislature has graciously written for you in case your will isn't valid or you haven't done one at all. Now, if we have a trust-based plan, we use what's called a pour-over will, and it pays the assets to the trust. Ideally, we would like to avoid having to go through probate to do that, but sometimes you don't have a choice. The box can also name the trust as the beneficiary, and the box can also name the probate estate. And if all else fails in the box, the probate estate becomes the default. Now, all of these methods get assets to beneficiaries, but they're not equal in the way we do it. So we're going to take a look at these from an administrative standpoint. There's four things we have to look at. You're always going to have to look at case law, banking regulations, the Internal Revenue Code, and the Treasury regulations. Right of survivorship and beneficiary designations have one common set of rules. The very first thing you should note about them is that the IRS has special bad tax rules that apply. There's more than one, but Section 1014 is a famous one. Right of survivorship and contract, that's what beneficiary designations or TODs are called, contracts. In each state where you have owners, survivors, beneficiaries, or where assets are located, you can have several laws that come into play. The estates or probate code, the property code, the insurance code, and the family code, and there could be others. If it's owned by a trust, you deal with one state's law. The law of the state where that trust is written. Here in Texas, that would be the Texas Trust Code. If it's owned individually, you have to go through probate in each state where real property assets are owned. And you have to look at their estates or probate code, the property code, and sometimes other laws can come into play as well. As you look at these administrative rules, the simplest way to pass assets is through a trust. Right of survivorship, beneficiary designations, TODs seem very simple, but they can turn into a nightmare, and I'm going to show you a case where they do exactly that. Probate technically means to prove up the will, but I like the layman's definition better. It's the court-supervised transfer of assets for someone who has died. People always want to know two things about probate. How much does it cost and how long does it take? No one who is being honest with you can answer those questions in a straightforward manner. It is not possible to know. Here's what you should ask. Who gets paid first and who controls the process? So under Texas law, here's the order of who gets paid first. Funeral and last illness up to $15,000 each if the court approves. Now, if you're not an attorney and you see phrases in the law like if the court approves, courts approve things because lawyers go argue it. That is not the least expensive way to do anything. The family allowance, good for 1 year if we have qualifying family members. In this case, or at least in the case of Carl and Myra, Paul would be a qualifying family member after both Carl and Myra are gone. Then comes the cost of administration, attorney's fees, court costs, executor safekeeping, managing the estate, unpaid guardianship fees. Then comes secured claims and tax liens. In some cases, unpaid child support and interest. Taxes, penalties, and interest. That's the IRS. I hear everyone cheering because Texas has 5 people in front of the IRS. Isn't that great? Then comes the cost of confinement if the person was in jail or prison. Then repayment of medical assistance if they were on Medicaid. And then other claims that are generally unsecured. If you have a rental owner who goes through probate, I have seen cases where the kids were unable to collect rent, sometimes for as long as a year, because the person who the rent was being paid to has died. They can't cash the check anymore. Now, did you notice who is missing from the list? Well, it's the family and loved ones. They are last on the list of who gets paid. But who controls this process? I wish I could tell you that it's the courts and lawyers, but it isn't. It's people who make claims. Here's why nobody can tell you what probate's going to cost. No one knows how many claims will be made. No one knows when those claims will be made. As you'll see, that can be as late as 4 years later. Nobody knows what it'll cost to resolve those claims. This is just totally unknown, which is why somebody giving you a straightforward either doesn't know what they're talking about or they're lying. Now, how long does probate really take? Well, typical probate, minimum of 6 months. Distributions made prior to this are at the risk of having beneficiaries have to pay it back. And if you're the executor and you've got to go back and get it from your pesky brother or troublesome sister, you may have a problem. They may not pay it back, and you will get stuck with a bill. Typical range of times is 8 months to 2 years. Claims can be made up to 4 years. Some cases drag on for many years, even decades. I got involved in a case once that literally had been going on for almost 30 years. My definition of probate is it's a lawsuit you file against yourself at your own expense to protect your disgruntled heirs, your creditors, and your future lawsuit creditors. And I have never had a probate judge tell me I'm wrong about that. Now, for special needs, there's another issue that I don't normally mention with probate, and that is that it's public. There is always some risk of bogus claims being made against the estate. And sometimes the will just says pay all debts, and you don't have any way to contest potential debts, which really opens the door for bogus claims. There's always some risk of a predator trying to separate a beneficiary from their assets. I've seen that come up. But in the special needs context, it's even worse. There's all kinds of scammers out there, and you're just giving them a ton of information when you go through probate. Here's an example of a probate case. Merlene died. She had 3 children, Harry, Don, and Norma. She died on a Sunday. 8 days later, Norma came to us to probate her mom's will. 80% of the assets passed by right of survivorship, TOD, and beneficiary designations. Those percentages are important. It's why I put them on there. 20% is going to pass through her will. She has a home here and a property in Wisconsin. It's the only two things subject to probate. Both of her sons are in second marriages. Merlene didn't like either one of her new daughters-in-law. Now, what happens? We're going to go through these one at a time. Norma's right here in Texas. It's her first marriage. She has kids, no issues. The hot Texas real estate market explained why she showed up at our office the day after we gave her a package on Monday. When we got here Tuesday, she was waiting for us to open. That's when I learned that 80% of the assets passed by right of survivorship, beneficiary designations, and TOD. She's going to get her share generally outright within about a month, but no protection to her. 20% is going to come through the probate in Texas and Wisconsin. She can't sell the Texas real estate until at least the will has been probated. She can't sell the Wisconsin real estate until after the Texas probate. Then they can open the Wisconsin probate. Generally, she's going to get those assets in 8 months to 2 years. Harry lives in Illinois. He's in a second marriage. He has prior marriage, minor children. Now, he died the morning after Norma came to see us. 80% of what he has will all go to his new wife. Here's why. Right of survivorship vests in 5 days, both in Texas and Illinois. Beneficiary designations and TOD vest immediately. They're now going to be controlled by his simple will, which gave everything to his new wife. The 20% from his share that's coming from the will, well, he did not survive Merlene by 30 days, so he's going to be treated as though he didn't survive her and treated as though he predeceased her. Therefore, it's going to go down to his minor children. They ranged in age from 5 to 12. Now, all those things that you think were going to avoid guardianship and probate, guess what? They've got 3 probates, one in Texas, one in Wisconsin, and now their dad's probate in Illinois, and a guardianship proceeding in Illinois. The good news is they're going to get what comes out of the probate at age 18. It's a great recipe for them getting a nice car, but no college. Merlene loses control of 100% of this share. Now, what if Harry had a special needs child like his brother Don? I'm not going to address that, just ask the question so you can kind of think about it. Don is in his second marriage. He lives in Wisconsin, and his prior marriage children are adults. He does have one severely handicapped adult child. His 80%, 30% passes by right of survivorship and TOD. They're paid within a week. And when he got a call from the bank telling him he needs to come open a new account, he told them that on the same day that Norma came to see us. And he said he'd be over the next day. But beneficiary designations haven't paid yet. That's actually going to work in his favor, as you're going to see. Well, Tuesday, before he heads off to the bank, somebody delivers a package to his house. He opens it up. His wife is suing him for divorce, and he spends the day finding a lawyer. Wednesday, his brother dies. Now, think about Don's situation. Mom died 10 days ago. Yesterday, after 9 days, he finds out he's going through a divorce. Today, his brother dies. He's stressed out, which will explain why he did what he did. He put the right of survivorship and TOD in a joint account with the wife who is suing him for divorce, and he goes to the funeral. Now, his wife did not take all the money. That was my fear, that she could have taken all the money, and she could have, but she wasn't that type. However, under Wisconsin family law, she's entitled to a third of it when he put that money into their joint account. Merlene loses control of 1/6 of what was going to Don. And you have to consider that that also wipes out 1/6 of the assets for Don's special needs adult child. What happens to him? Now, Norma asked me, what else could Mom have done? And I said, well, Mom could have used a trust. Here's how that would have worked. All the assets would have passed by terms of the trust and would have been more favorable to everyone in the family. It would have avoided probate in both Texas and Wisconsin. Norma's share would have been all for her benefit. It would have been protected from existing creditors, future lawsuit predators, and divorce. Harry's would have all gone for his minor children's benefit, would have avoided guardianship, provided for their college, protected them from existing creditors, future lawsuits, and divorce. Those kids would have been way better off than what happened. Don's, all of his share would have been in trust. It would have been for his benefit. His wife wouldn't have been entitled to anything because it could have protected Don from creditors, future lawsuits, and divorce. Don's special needs child could have been cared for without any asset loss. Now, while a trust maker is alive, trusts can avoid guardianship for assets in the trust, provide instructions for care in case of incapacity, give you a chance to see how successors manage assets. They're easy to manage, change, and update. They can have special needs planning for the future. And they work best if assets are fully aligned. I've already mentioned that. And what that means is getting the assets either owned by the trust or having those assets pass by making the trust the beneficiary of those assets. Managing assets outside the trust may require court oversight, and it makes it easier for creditors to come along and take it. Lack of asset alignment makes administration more complicated. You may have to do trust administration, probate, guardianship. Think of Carl and Myra, 2 probates, 2 guardianships, and then dealing with Paul. Trustee has to know and apply multiple sets of potentially conflicting rules. The trustee is better off aligning the assets to use one set of rules and avoid guardianship and avoid probate on down the road. Now, remember what I said about the flight attendant. Take care of yourself first. You need to carefully plan for the special needs individual. Don't make them ineligible for programs. Coordinate planning to avoid assets going to unintended people. You want to keep the courts out of this as much as possible. Planning is going to take more time, but it is going to be time well spent. It is going to cost more if you've got special needs folks in the family, but the cost is small compared to not doing it right. Now, I'm going to not talk a lot about tax dragons, but some of you may have heard of the new Friendlier IRS. We had a case with them a few years ago. Here's our picture of them. You'll be pleased to know he's using a poly Teflon blade for a smoother, less irritating cut. If you don't remember anything else about taxes, remember this. The IRS is only in it for the money. Now, when a person dies, the IRS literally declares war on the family. They're going to bring their ship into your harbor. We call this ship the IRSS Your Money. The thing missing from this ship, you're probably guessing sails, but you would be wrong. It would be the pirate flag, because the IRS is there to haul your money off to the U.S. Treasury. That is their job, and they're good at it. The family has 2 choices. They can raise a white flag, get out the checkbook, and write the IRS a check for whatever the IRS says. Or consider the 2 tax systems we have. One is for those who are uninformed or who are unwilling to act on advice they've been given. The other is for those who either are educated or they seek wise counsel and who act on that education or advice. That's the group that pays the least in taxes. Which group are you in? When you have special needs, it's important, especially that you hire professionals who are somewhat familiar with special needs. Make sure they know the tax rules and how they affect special needs. Apply the tax rules, act on the rules, use multiple tax strategies where appropriate. Now, I'm going to show you a typical married couple tax plan with special needs trust. We're going to use an AB plan. I'm not going to spend any real time explaining it, but it makes sure that we get to use both shares. It makes sure that if the surviving spouse gets remarried, at least part of it went down to the beneficiaries that they both agreed to. And it's going to have a component typically for special needs planning as a lifetime beneficiary. And then you need to know the real needs of that special needs person. And then other planning for non-incapacitated beneficiaries. Usually they're going to get some immediately, and usually they receive what's left over from the special needs trust after the special needs person's death. Lifetime and after death planning, we've mostly focused on death, but you can set up a special needs trust while you're alive. Others can contribute if you set it up correctly. Determine the eligibility requirements of agencies you might be working with. You need to determine the requirements regarding financial issues as well. You should seek outside sources, especially for funding. Standalone special needs trust created while you're alive. It can be funded by gifts, lifetime gifts from parents, grandparents, aunts, uncles, nieces, nephews, even siblings. You can also make testamentary gifts. Testamentary gifts means gifts that come after death, typically in a will. The beneficiary cannot be a trustee. You have to carefully draft to avoid loss of benefits and plan carefully for the income generated. Also, you don't want to give that special needs person a power of appointment. That can make them ineligible, and a power of appointment simply means that they have the ability to say where it goes upon their death. And normally what you're going to want is to go to non-incapacitated beneficiaries. Special needs trusts protect the eligibility for government benefits. They provide for a higher quality life. They provide a framework for the care and management of the assets. It allows parents to express their desires for their kids and others they might want to see benefit. Protects the assets from creditors and predators. Now, not all trusts do that, but special needs trusts should be able to do that. It's going to extend the life of assets. Again, it's going to take more time and cost more, but it's time and money well spent. It avoids many of the costly mistakes people make when planning for their child with special needs, and here's some of them. Disinheriting the child, I'm going to address that specifically. Relying on other children to provide for a child with special needs. Failing to provide privacy for the child with special needs. Choosing the wrong professionals. And it costs more, but again, the cost is small compared to doing it right. One strategy that's out there is disinheriting the child. Honestly, that's short-sighted. Public benefits provide minimal levels of help. Your special needs child depends on you more than your other children do. Relying on siblings might be a workable temporary solution, but for the long term, there can be serious drawbacks. Siblings may not have the financial resources. They just may not be able to provide care in their home or have the resources to go check on that special needs child. They may not have the emotional resources. It's very draining. And parents God gives them a built-in love for those special needs kids, it seems like to me, but that isn't always passed down to the siblings. What if a sibling goes through a divorce or has other creditor problems? Well, the answer is the assets you intended for the special needs child could wind up going to the sibling's ex-spouse or creditor. You don't want that to happen. What if that sibling becomes incapacitated or dies first? You need a backup plan. Attorneys who are not experienced in this area can actually do more harm than good. Experienced financial advisors can help maximize resources to benefit the child, and they can provide some other ideas for funding. Some commercial trustees can help a lot. Not every commercial trustee is good in this area, but some of them are great. There are three kinds of special needs trusts: third-party S&Ts, pooled S&Ts, which I'm not going to address, but they're managed by a nonprofit and they're individual accounts within a pool of accounts. And then there are self-settled special needs trusts. I'm not going to address that either, but they're self-funded to qualify for government benefits, but typically they have to be paid back from the estate. Sometimes it's still worth it. Third-party S&Ts can be established by will or during lifetime. If established by will, you're going to have time-consuming delays, additional probate expenses, and then what if the will isn't probated? Sometimes you can't get it probated for one reason or another. What if laws change? I'll tell you what happens in that case. You're stuck with those laws. If you establish it inter vivos, that means while living, that means setting up a trust. It's in effect immediately. Trustees and successors get training and experience. The trustee can be the beneficiary of life insurance and other resources. Grandparents can even leave an inheritance to the trust on their death. And if laws change, you can amend the trust even after death, assuming that you have drafted for that possibility. The trust should reflect your child's uniqueness. Special needs kids, they're different and their needs are different, but they're unique. There's such a wide range. They don't all need the same thing. Generic trust can leave the trustee with very little guidance on what your child needs, and that can definitely hurt your child. The trust should reflect your knowledge and insight into your child. If you're not seeing that kind of language drafted into the trust, you probably don't have the right kind of trust. The trustee should get experience managing the trust, so it's important that you teach others how to manage the trust. It gives you a chance to work out kinks in the plan and put a team in place to meet your child's unique needs when you are no longer there to do it. And the plan is in place. If you become incapacitated, it's already operating upon your death. So the point is, setting this up while you're alive makes the most sense. Initially, choose for yourself and your spouse. Then you choose someone who you think will do all of the following. They will care for your child. They're willing and able to devote the time and energy. They have the ability to manage the assets properly. They're willing to learn. They're willing to seek advice, and it's someone you trust. Professional trustees, there's some disadvantages of them. One, they're not going to be as attached to your child. Two, they may be less responsive. But there are also some advantages. They're bonded or insured. They're more likely to properly manage the trust, and they provide excellent record keeping. They do charge for their services, but all trustees should be compensated, especially in the special needs context. Special needs individuals, selecting an individual and a professional together to serve as co-trustees is a great idea. That individual will care for your child and be more responsive. The professional can do some of the heavy lifting. And between the two of them, they balance each other out. Asset protection means protecting and preserving assets from unnecessary loss, or how do you avoid being the victim of the lawsuit lottery? Well, if you have a special needs child, don't ignore this area of planning. You can't ignore the risks of your beneficiaries after they inherit assets. And so I'm going to tell you some of the big major problems. One is the failure of special needs planning. Totally disastrous for the child whose special needs can make them ineligible for other government programs. And that's just devastating when it happens. Your child's spouse's divorce lawyer is typically the number one risk to your estate plan. Beneficiary debts, and I'm talking about extraordinary bills, especially medical bills. Maybe they were hurt in an accident or something and it wasn't completely covered by insurance, or uninsured or underinsured loss. Had a neighbor's house burn one time and it took the better part of 2 years for them to rebuild because they didn't have enough insurance. And unfortunately, that saddled them with a whole lot more debt to rebuild that house. So your kids don't have control over that. Predator threats, future lawsuits can really affect your beneficiaries. Does a beneficiary have a high-risk job? You need to ascertain that. What state do they live in? The rules vary from one state to the next. Texas is a great state to do asset protection planning in. How would the loss of those inherited assets affect your beneficiaries? And how would it affect that special needs child? Now, when the beneficiary receives assets, there's three basic ways they get it. In a payout trust, which provides no protection from future lawsuits, guardianship, probate, or divorce. You can set it up in a convenience trust. It at least avoids guardianship and probate if they'll leave it in the trust. It can protect from a child's bad money management. It is a separate property of that child and can even bypass that spouse for estate tax purposes in the next generation. However, it is limited protection. You can use a fully protected trust. We have two of these that we use, what we call the Heritage or Ancestral Trust, but we're not the only firm out there that does that kind of thing. They offer everything that a convenience trust offers, plus creditor and lawsuit predator protection, bad marriage protection, first death in marriage protection, loss of government benefits, and dynasty trust that it can go on forever. Well, 300 years. I've been telling people I'm going to retire after a couple of 100 years, so I won't be around for that 300 years, but Texas allows you to pass it 300 years after the death of the last named beneficiary in your plan. That's a long ways off. You get to choose which of these three you're going to use. Now, I'm going to show you an example of a convenience trust. Carrie inherited from her parents $3 million. Nothing went to the IRS. Great job of tax planning. But she was involved in a car accident in Massachusetts. Somebody tried to go around her at an intersection, clipped her bumper, caused her to veer off. She T-boned a van load of daycare kids, killed the driver and 2 kids. There was a lawsuit after that accident. The jury came back with a $9.8 million judgment. They found Carrie's, the person who hit Carrie, to be 90% liable, but they found Carrie 10% liable. I don't know why. I wasn't there. Some people think, well, Carrie has to pay $980,000. That's sad. No, that would have been a welcome change to what really happened. Massachusetts is a pure joint and several liability state. That means if you're 1% liable, you can pay for the entire thing. Carrie lost her entire inheritance. By the way, if you have a child who lives in California and they heard about the accident, they could pay for it. Okay, that was a joke. Compare that to the Ted Kennedy story. In 1969, in Massachusetts, he drove off the Chappaquiddick River Bridge when he was drunk, 100% at fault in this accident, and Mary Jo Kopechne died. Ted Kennedy's parents had done what we call a heritage trust. The Kopechne family could not touch it, even though there was tens of millions of dollars in there. Then Ted Kennedy went through a divorce with his wife Joan in 1982. Joan could not access that heritage trust. That should not have been a surprise to her. But what may have been a surprise is to learn that the assets in that trust couldn't be counted against Ted Kennedy in the divorce. So the judge had to treat it as though Ted Kennedy was penniless, except for what they had. Then he remarried a lady named Vicky. When when Ted Kennedy died, Vicky discovered, like Jacqueline Kennedy and Ethel Kennedy before her, that since her name didn't start out in life as Kennedy, she wasn't entitled to anything. That is 3 ways that Heritage Trust helped Ted Kennedy and the Kennedy family. You can do the same thing for your family. Do you think protecting assets for beneficiaries makes sense? Well, I asked 3 questions of families. What are your risk factors? I'm surprised at how often people don't realize the things they're involved in that can create very high risk. What assets do you own that are at risk? Under Texas law, some assets can't be taken away from you, no matter what, or at least not by regular creditors. And then how would the loss of those assets affect you? You really need to do an assessment of this, especially if you have a special needs child. And just remember, that's the dragon that just seemingly comes flying out of nowhere that nobody's expecting. Now, special needs trusts and heritage trusts for non-special needs have a lot of things in common. In fact, under Texas law, you can actually use a heritage trust as a special needs trust by simply adding a couple of fairly minor provisions to it. You can put bloodline protection in there. You can keep assets out of a beneficiary's taxable estate. You can allow special needs folks to be the lifetime beneficiary of the shares of other beneficiaries before it goes to others upon their death. You can have a trust that will go on literally forever, kind of like what the Rockefeller family has done, where they only get income out of it, the beneficiaries. You need to identify personal risk and plan accordingly, and you need to pay attention to the risks of your kids. Create structures that are difficult to get through, get others involved, partition assets, manage the asset protection like a business. I've already mentioned they have a lot in common. The big thing is you can't let the special needs person serve. Look for planning gaps before the planning, cover those gaps. Don't try to do this without qualified professionals. All right. We plan by analyzing the family situation, the financial situation, determining your goals and objectives, analyzing the specific tools, and then consider what you're trying to protect, who you're trying to protect it from, and what tools might work. And then plan for the special needs family member. Every case is different. Before planning, everything is at risk. There's a dragon that'll come by and snatch your bag of money. Our goal is to put you behind a castle. The dragons will still come, but now you have a knight and a castle to protect you. It's important that you decide to get serious about estate planning, especially if you have special needs people in the family. Planning is an expression of love and devotion to your spouse, children, and the causes you support. If you haven't done it up to this point, do it now. If not now, when. Okay, we're ready for the next presenter.
Sheila. Okay.
Yes.
Okay. Go.
Yes.
I didn't know Sheila was going to come on to introduce you.
Yes, I would be so happy. It is my pleasure to introduce you to a new friend who has a special needs child. And so this is very important to her. And she wanted to be a part of this to give you, to let people know that have special needs children or a special needs person in their family, there are options out there for respite care. Because the problem is, oh, I see that you can't see me, my bad. The problem is that you need a break sometimes. We have the same situation when the family has a loved one with dementia, Alzheimer's, and you need a break because caregiving is a huge responsibility. And sometimes you need a break. But where do you find a place or someone to help you with that break? Well, that's quite frankly, they are few and far between. I'm gonna be honest with you. Of all the home care and the healthcare places that I know of, not a lot of them do have the ability or the option to take on a special needs client, but there are some that do. And this, my friend Danya is going to tell you about how important that may be to you, what that could include, and what to look for. Remember, we are just educating here. All three of us are just educating here. Our companies are. We're just trying to give you resources to help you, your family, and your clients. Without any further ado, Danya.
Thank you, Sheila, for the introduction. As Sheila mentioned, my name is Danya DeLeon, and I'm here with a couple of my team members today, Joel and Nicole, to talk to you about respite care services. Next slide. Before we get into that, I'd like to tell you a little bit about my journey. My son was diagnosed with ADHD, and he faced significant behavioral challenges. This was particularly difficult as ADHD is often overdiagnosed, leading many to dismiss his energetic and challenging behavior as mere misbehavior. With my husband's busy work schedule, the responsibilities of finding solutions fell largely on me. Determined to help him thrive in this world, I navigated this journey while also attending to my other two children who needed my attention. I explored every available resource. I looked into neurofeedback, parent-child interaction therapy, craniosacral therapy, sound therapy, positive parenting, intense sports, occupational therapy, behavioral therapy, and much more. It was a chaotic and overwhelming period, especially since I needed to constantly supervise him for safety. And that was during the beginning stages up until about 6 years old. And slowly, little by little, he's been adapting more. And we have rocky roads. Sometimes we come up with other challenges. Like recently, he was in the hospital for he lost the ability to walk due to his body adapting to stress badly, and we have recently overcome that as well. This experience has taught me the importance of support. I was often worn down, reinforcing my belief that the best kind of mom is the one who is rejuvenated and can think clearly to make the best decisions for her family. Next slide. Okay, so what is respite care? Respite care can provide temporary relief. Respite care provides temporary relief for primary caregivers, allowing them to take a break from their caregiving responsibilities. It's professional support. Respite care is delivered by trained professionals who understand the unique needs of individuals with special needs, short-term or long-term. Respite care can range from a few hours to several days or weeks, depending on what is required. It can enhance well-being. It helps reduce caregiver stress and prevent burnout, promoting overall family well-being. And it's personalized. Services are tailored to meet the specific needs of the individual with special needs, ensuring they receive appropriate care and attention. Next slide. Now there's two different options here. There's respite care, and I'm going to go over the differences between respite and attendant care. Respite care is designed primarily to provide temporary relief for primary caregivers, giving them a break from their caregiver duties. Typically, it's short-term and can be scheduled intermittently, ranging from a few hours to several days. It may include a wide range of services such as companionship, supervision, and basic care tasks, tailored to provide temporary support. Now, attendant care, it focuses on providing ongoing assistance with daily living activities for individuals with special needs, often on a regular or long-term basis. It's usually more consistent and long-term, with caregivers often providing daily or regular assistance as part of a structured care plan. It typically involves more comprehensive and routine assistance, including help with bathing, dressing, eating, mobility, and possibly medical care based on the individual's needs. Okay, next slide. And that's all I have for you today. Thank you so much for allowing me to share. Here's my contact information. Yeah. Yes, here's my contact information if you have any questions. Thank you.
Okay, yes, I know. I'm back. I was trying to answer a question too, but anyway, and I see there again, you can't see me. Okay. Again, stop. I know that was helpful. That was very fast. And now we have people asking if they can also have the recording because they loved your story. So yes, I'm going to address this publicly. Marty will send out the recording after a while. It takes him a while to get all of this done because he is so busy with all of these. But he will send out the recording, the link to the recording as well. So anyway, but now you may be thinking, okay, that's great. But how am I going to pay for this? You may be thinking that. Okay, well, I have a friend that is a Medicare specialist, and you may think to yourself, well, what does that have to do with special needs? Well, it has a lot to do with special needs. And the reason I asked her to come on here is because there are government programs like Rex had mentioned with planning. Medicaid in particular is very important for special needs. And that can sometimes be addressed, but what you don't or may not know is that you could get a dual help. You could possibly qualify for Medicare and Medicaid at the same time, and your insurance is incredible when you can do that. Can you do this yourself? No, I'm gonna be honest with you. Don't try to do Medicare yourself because it's ridiculously hard to do. You need a professional. So remember, we are just here to educate right now, but I want to tell you, I want you to learn about the options here because this is very important. And it's my friend Joanne that is going to educate us on the insurance possibilities that may be available for your family. Without any further ado, Joanne.
Thank you so much, Sheila. It's great to be here. Good morning, everyone. Excuse me, happy to talk about excuse me, Medicare and Medicaid. So we can go to the next slide now. So I always say, you know, Medicare, Medicaid, it's very confused, very, very confusing. And like Sheila said, it's really hard to do this on your own. So I have a simple mission. Is to help people understand what their health insurance needs are. Oftentimes, people aren't really sure until we outline exactly what their needs are. And of course, with a special needs situation, those needs are enhanced, of course. assisting you in securing a plan, excuse me, to meet those needs. And also providing you with the resources necessary to utilize your benefits so you can live a healthy life. This is really important. There's a lot of resources out there, and I actually have some handouts here that I'm happy to send over electronically. They're taken from some of the governmental sites on Medicare and Medicaid that have really great information. So happy to send those electronically if anyone would like those. It's important to know your resources for sure. Okay, next slide. So let's start by defining Medicare and Medicaid, because many times people get these two mixed up. I hear many times people refer to Medicaid by saying Medicare, refer to Medicaid, Medicare with Medicaid, and so forth. So Medicare is a federal health insurance program. It's in the US. It did start in 1966 under the Social Security Administration. It's now administered by the Centers for Medicare and Medicaid Services. That is the umbrella, and it's also called CMS. Medicare is primarily for individuals aged 65 or older, but also for younger individuals with disabilities. And also another qualification for Medicare is anyone with end-stage renal disease, and that's newer within the past 2 years. Medicare in and of itself, original Medicare, does provide 4 parts of coverage. Part A is your hospital insurance. Part B is your medical insurance. Part C is a Medicare Advantage plan. And Part D is prescription drug coverage. Okay, we can go to the next slide. Okay, sorry, I thought we missed a slide. So the eligibility, who's eligible for Medicare? Remember, this is a red, white, and blue card that you may have family or friends or may have seen this card. You're at least 65 years old or under 65, and you qualify based on a disability or another special situation. And you're a U.S. citizen or a legal resident who has lived in the U.S. for at least 5 consecutive years. So I want to also quote here that under 65 and qualifying for a disability, if someone has a disability, and this would be under SSDI, Social Security Disability Insurance, they're automatically qualified and enrolled onto Medicare after 24 months. So that would be 2 years. And that's an automatic. Many people are not aware of that. Also, I have people coming to me asking this when they're collecting SSI, which would be Social Security. That does not qualify, unfortunately, unless there's another qualification in the income or what have you. But the SSDI, Social Security Disability Insurance, at any age after 24 months, they're automatically on Medicare. Okay, next slide. So now let's talk about Medicaid. And first thing I like to tell people is that the way to remember the difference, think of aid, right? Medicaid is about aid. It's about helping, right? It's about helping people that need the help. So Medicaid is a joint federal and state program. It provides health coverage to low-income individuals and families. It includes children, pregnant women, older adults, and people with disabilities. Medicaid is the single largest source of health coverage in the US, and it covers 77.9 million Americans today. So the coverage and eligibility criteria, it does vary by state, and it's determined by the income, the whole household size, category, and also asset level as well. So for children up to 18 years old, if the household income is at or below 201% of the federal poverty level, they're going to qualify for one of the Medicaid programs. Also, pregnant women, the household income at or below 198% of the federal poverty level. Adults with dependent children, there's varying levels of thresholds there. They're very low. And older and disabled, their income and resource limits are, again, on a spreadsheet chart. So just to give you an idea, if you're working with someone who has approximately $1,700 gross income coming in or less, per month, it's a very, very good idea to have them apply for the federal program Medicaid. Often there's different levels of Medicaid. We'll go through that in the next slide, but you always want to make sure that you're helping your client or whoever it is you're working with maximize whatever assistance is out there. So if there's any question at all, I would suggest to have someone help you or enroll, have them apply for the program just to make sure that they're receiving the maximum amount of resources available. Next slide. So in Texas, we have different programs. This is kind of I think of it as an umbrella. So there's many programs underneath this umbrella of Medicaid. One of them is called the Children's Health Insurance Program, or CHIP, and it provides health coverage to children and families with incomes that are a little bit too high to qualify for Medicaid, but they're too low to afford private insurance. And many people don't know this. There's a lot of working people who unfortunately today are able to qualify for this, but don't realize there's help out there. The next one is a Medicaid buy-in for adults and children. This allows working individuals with disabilities to buy into the Medicaid program by paying a monthly premium. And that's pretty rare that people know about that program. So underneath this Medicaid umbrella, if you will, are 4 different levels. One is called the STAR program. Another is called the STAR Plus program. Then there's a STAR Kids program, and then there's a couple other specialized programs. And they all differ. They differ in terms of eligibility by income level and resources. Next slide. So something else that is another program available that I find many people, if not all that I work with, do not understand extra help. So when someone's on Medicare for any reason, doesn't matter the reason, there is something called extra help, and it literally is called extra help. It's also called LIS, or low income subsidy, if you ever see that acronym, LIS. If you qualify for extra help, members or beneficiaries can get help with paying for the drug plan's monthly payment, like premium, so there's no premium. Anyone qualifies for extra help, premium is waived. It also covers yearly deductible, co-insurance, and co-payments for covered drugs. So the LIS program, or extra help program, is set for assisting people with the prescription part of their Medicare. Now, we all know how important that is today with the cost of medications just drastically going through the roof. This is so important to make sure that your client knows about this and is able to apply because they may be eligible and not be aware that there's assistance out there. The Medicare Part D structure is very complicated. I'm not going to explain it all, but there's different levels to it. And there's one part of it that's called the coverage gap, or a donut hole. And that's where when this gap exists, according to the cost of your medication, you're actually paying more for that medication. When someone's on this extra help, there's no coverage gap stage for them. There's also no late enrollment penalties. Occasionally there's late enrollment penalties for different situations, for coming on to Medicare without prior coverage, or lots of different scenarios. All of those are waived when someone has the extra help program. So it's super important to make sure that I always check everyone that I work with to make sure that that they, to see if they qualify for the extra help. And then under Medicaid, the state provides health care coverage for people with families with limited incomes, and those programs vary by state. Now, those are called the Medicare Savings Program. I think, yes, I'm sorry, I thought it was from another slide. It helps pay for your Medicare Part A and Part B. So if you're working with someone who is either disabled or low income or has had a drastic change to their finances, it's always a really good idea to know these resources exist. There's applications that can be enrolled online. There's numbers that can be called for assistance. There's many resources for them, and it's a very good idea to make sure that that they are, you know, that they are applying to make sure that they're getting as many resources as possible. So we're going to talk about what some of those resources may be on the next slide. So what happens when someone has both Medicare and Medicaid? I have heard everything from that can't happen, which is incorrect. When you get Medicaid and you're already on Medicare, you lose your Medicare, incorrect. When you're on Medicare, you can't have Medicaid. I've heard it all. So that is all not true. The coordination of Medicare and Medicaid is very real. Someone who's already on Medicare, whether they're 65 or older or disabled, they're also low income, and they've either had Medicaid prior to their becoming eligible for Medicare, or perhaps becoming eligible for Medicare puts them in the category where now they are eligible for some state assistance as well. And I do find this fairly common today in the population of folks that are retiring. So underneath this is how these two work together. So there's something called DSNP. You may see DSNP as the acronym. It's called a special needs plan. And these are designed for those who have both Medicare and Medicaid eligible. And they're separated out because they're coordinated differently than a typical insurance plan. We'll go through that in just a minute. There's also full Medicare Advantage plans where the premiums and benefits are subsidized in full or partially, depending on the level of Medicaid. So this is where someone, maybe they would apply and enroll in a partial subsidy. Then part of their out-of-pocket expenses are being covered by this Medicaid program. There's Medicare Advantage plans. They offer more benefits than Medicaid alone. So when someone has Medicare and Medicaid, they may say, well, I don't need anything else because I'm already getting benefits. I have my original Medicare, and I also have some benefits for Medicaid, and it's true, there are some benefits. However, what they may not realize is there's Medicare Advantage programs that offer more benefits than just the Medicaid alone. They don't take away from the Medicaid. In fact, they add to what the beneficiary is eligible for. So for instance, dental plans, which is super, super important, and the typical dental programs that are on the Medicaid programs are pretty low. So this would add more dental for them. Vision, hearing, which is hearing aids, which many people who are aging need that, or disabled. There's gym benefits, an over-the-counter benefit that is very helpful. This would be for anything that a beneficiary would purchase in a drugstore that's not a prescription. Pest control, super important here in Texas. This is newer, but very, very important. Grocery subsidies, where there's a debit card given, and I've seen all kinds of different amounts, varying amounts, so that some are substantial, where this beneficiary can receive, help with their grocery money. Electric, phone, and cable bill subsidies. Of course, this is depending on the plan. There's many, many plans out there, and many plans under each carrier that are completely different. So of course, it depends on the plan. Those are things that I have witnessed helping others get on plans like this and watching them, have availability of more dental, more vision. They can hear, they're getting their fitness in, they're getting subsidies on groceries. It's just so rewarding to see that they're maximizing their benefits. So the way it works is that someone would have a Medicare Advantage plan. They'd have Medicare first, their Medicare Advantage plan, and then they'd have the Medicaid card as well. Because these plans are called DSNP, or dual special needs plans, there's an automatic coordination of benefits that happens. So when the beneficiary is receiving care at any provider, any provider's office, the Medicare Advantage plan would be billed first. And then there's a coordination between the Medicare Advantage plan and the state Medicaid. So the member does not have to do anything in terms of billing. All they need to do is share their Medicare and Medicaid cards, as well as the Advantage card. And then the provider's offices handle it all. And as a matter of fact, if someone has the full Medicaid, they are not billed for any copayments, deductibles, or balances due. They're all billed to Medicaid. And in fact, it is required for Medicaid to pay it or write it off. They can't be balance billed on the highest level of Medicaid. There's certain other levels where they can be balance billed a portion. Again, it depends on what their eligibility is. But this is a huge benefit for people that are, needing lots of medical care that we all know can be super expensive. So on the medication side, they're either covered in full or partially covered with very low maximum caps, depending on the level of Medicaid. So anyone who has Medicaid is automatically going to have the extra help with any level of Medicaid, even the lowest level. With the highest level, they're all going to have extra help. A lot of them don't realize it. They don't realize that they're able to get their prescriptions for a lower cost. Next slide. So I went through a lot of information. I didn't want to overwhelm and give too much. Like I said, I do have some additional documents here. If anyone would like us to send them out, we're happy to do that. Taken right off the Medicaid and Medicare websites. But thank you again for allowing me to share this information. And if anyone has questions, I'm happy to help.
Well, there are questions. So, all right, now we're going to get to the questions portion.
Just real quick, Sheila,
Sure.
since we're past the 11:30 mark, can we go over the CEUs real quick for those people that have obligations, have to sign off? I'm sorry.
Oh, no, that's fine. That's fine.
Yes. For those of you that are joining us today for CEUs, we are providing complimentary CEUs for licensed social workers and licensed professional counselors in the state of Texas. If you have a different license in Texas or a license outside of Texas, feel free to go through the process and get a certificate and submit it to your jurisdiction. But please note, there's no guarantee that they will take that. We're also offering certificates of attendance for those of you that would be interested in those. Today's presentation is worth 1.5 hours of CEU credits. You must have completed the entire live webinar and the Q&A and stuck with us till at least 11:30. Since we are going to go over with questions. You must complete the Google evaluation survey. That you should have an opportunity to click on that and to go to that as you close out of Zoom. If not, no worries. I'll send you that link in the follow-up email as well. The survey will be up and available to you till June 7th. Please make sure you complete it by then, and please give me till July 7th to get those certificates out to you. I'm going to turn it back over to Sheila.
Okay, we have several questions, and they're for all of you. Okay, so let me get to the first one. First one is for Rex. Megan wants to know, is it possible to stay out of probate with good estate planning, or is it inevitable?
It is very possible to stay out of probate with good planning.
Okay. Second one is for Rex. What is the difference between revocable and irrevocable trust? Is one better than the other?
Both have specific purposes. There are a number of different irrevocable trusts. We use both. Most firms who do estate planning use both. It depends on what you're trying to accomplish as to which one is the better.
Okay, now this one, there was one before that. Here it is. Okay, Teresa, this is another, I believe this is for Rex as well. My aunt has an adult child with mental health issues. He is not exactly special needs, but he lives in a bedroom in their home, has not worked in 25 years. Her concern about a trust is that she has seen ads from companies who can buy a trust for profit. Can the adult child somehow give a company the trust funds to get some of the money immediately? I don't.
Okay, I think I'm going to address the question that I believe she is asking. is there a way to stop a company from buying a trust? And the answer to that is yes. It can absolutely be stopped. There are companies out there that will buy all sorts of things for profit, but you can set up a trust that does not make that possible.
Okay. The next question is for Joanne. Joanne, this is Beth asking, how can I get my 20-year-old on in Medicaid since he's already approved for Medicaid waiver, but can't start services because he's not on Medicaid yet? I'm not quite certain of that either. I'm just reading what it says.
Yeah, I'm not quite sure what a Medicaid waiver is. I would definitely contact the Department of Health and Human Services, and they should be able to answer your specific questions, but I mean, typically there's an effective date you can request when you enroll or apply to have a 3-month retroactive effective date, but that's something you'd want to ask directly to the Department of Health and Human Services.
Okay, this next one is for you as well. Janice wants to know, do you have to apply every year?
I'm not sure what Janice means for Medicare or Medicaid, but for Medicare, no. Once you're on, you're on. And for Medicaid, the state assistance, no. But what happens is they will send out what's called a recertification. Many people miss this. And if it's not completed and sent in, then they are in jeopardy of losing their Medicaid coverage. So it's super important to make sure that you're completing that form. It's usually annually. In some cases, it's every 6 months, depending on your level of Medicaid.
Okay. And the next one is, okay, I see one coming up after this too. But anyway, Charla wants to know, what is the income limit? Oh man. For QMB/LIS Medicare premiums relief.
In 2024, for the state of Texas, for the QMB program, qualified Medicare beneficiary, the maximum gross monthly income is $1,255 as an individual or $1,704 as a couple. And you can find this information as well as other information and how to enroll or apply on yourtexasbenefits.com. We'll have all of this information as well, and that's where you actually would enroll.
Okay, I guess this one from David is probably going to be, David is a nurse. I think this is probably going to be for you as well, Joanne. How to handle a situation of a 41-year-old paraplegic on Medicare SSD, homeless due to poor planning by his now deceased mother, which Rex hinted at that if you don't do the right planning, things can go way wrong. Ended up in rehab, but unable to find housing and would have to give up most of his limited SSD, which I'm assuming is SSDI that he means, if he were to go into Medicaid LTC coverage. Is it possible to attain Medicaid LTC coverage without giving up most of his SSDI income? He has a vehicle outfitted for his disability that has expenses he would like to keep, but couldn't if he gave up most of his income.
Well, you mentioned initially SSD as opposed to SSDI, so it depends on the level. If he's receiving, he should be on SSDI, and if he's not, I would definitely have that researched to make sure that he's receiving SSDI. In which case, after 24 months, he'd have Medicare. So there's a lot of nuances to the question, and there's many different opportunities to explore. But in general, long-term, if LTC, I assume you mean long-term care, that unfortunately is not covered by Medicare or Medicaid, and that's one of the big surprises for people, is that long-term care is not covered medical skilled nursing in a facility, and some at home is covered if it's medically necessary for a short amount of time, but long-term care is not covered, unfortunately. What to do? There are some resources out there, and I'm happy to send those over to you.
Okay. Okay. Now, I have asked all of the questions that I have seen. Is there anyone else that has a question? Well,
It's
Oh,
pretty quiet.
yeah,
Pretty
I
quiet.
guess
I don't see any other ones coming
I don't
through.
either. I don't either. Boy, we did that pretty quickly. That's good.
Yeah, very
Someone
good.
mentioned the housing, help him apply for the housing voucher. That's another assistance program. The housing would be important as well. It's a good comment.
Very good. Very good. Well, thank you, thank you, thank you. Thank you, Sheila, for putting this all together. Thank you, Rex. Joanne and Danya, thank you so much. I appreciate it greatly. Great information. We certainly appreciate everybody joining us. And look for the follow-up email, please, and we'll get that information out to you. And it'll have the contact information for each of the presenters in it as well. Anything else that anyone wants to say before we close out?
Getting a lot of thank yous. I see that.
There you go.
And that's always good to hear because, you know, the reason that we do this, again, like I keep saying, is because we want to educate people as much as possible. And I realize a lot of you are professionals, which is fabulous. But I think you all know personally families that are special need or with special needs individuals that need this help and need these resources. Please pass this along to anyone, because an educated public obviously is better for all of us. But you know, that's why we're doing this. Marty is giving up his time. We're all trying to help you help others get the help that they need. And that's all we're here to do. And please, and also thank you. I mean, anytime somebody emails me with an idea for another topic, special needs was requested. So anytime anybody gets an idea for another topic, please, because we're always looking for what y'all need next. So anyway, and I want to thank Joanne and Danya for helping out as well, because this is very much needed in our community. So anyway, that's it for
Great.
me.
Thank you all. Thank you, everybody, for joining us. And you all have a wonderful day. Take care.
Thank you.
Thank you, everyone.
Thank y'all.